This contempt petition is dismissed on withdrawal with the liberty sought for granted.
Much obliged, my lord.
For admission item number 1.
Yeah, please, Your Lordship. Lordship, on behalf of additional AG, Wilkie Santam, pray for 3 weeks to file an affidavit in opposition, Your Lordship.
Good. What's her name?
Team
Miss T. Mitsio, learned counsel for the petitioner. Also heard Mr. M. Long Kumar, learned government counsel, submitting on behalf of the additional Advocate General, Mr. Imtin Sam.
No, LT Santam.
Sorry, LT Santam, and prays for 3 weeks time for filing affidavit in opposition. The prayer is not objected to by the counsel for the petitioner. Hence, same is allowed. List this matter after 3 weeks.
Obliged.
Item number 2.
Your Lordship, here also on behalf of additional AG, we separate. Pray for 3 weeks to file an affidavit in opposition, Your Lordship.
Lordship, actually, there's an urgency in this matter. In fact, on the matter relates to deferment of an exam, in special recruitment drive. And Lordship, the order dated the 12/12/2024, then when the matter was moved. This honorable court, in fact, was of the view that the matter can be disposed of on instruction. However, since then the matter has been delayed. I was informed, subject to confirmation, that instruction has been sent already. So my respectful submission, let it be listed after a week. Let's hope something positive happens, because, my lord, the matter relates to deferment of an exam.
Okay. Third, Mr. Takamasha, learned senior counsel, assisted by Mr.
Sendilong. Sendilong, Sendilong.
Learned counsel for the petitioner. Also heard Mr. M. Long Kumar, learned government counsel appearing on behalf of Mr. L.T. Santam,
V. Sokre.
V. Sokre,
Miss-
learned additional advocate general, and praised for 3 weeks' time for filing affidavit in opposition. Learned senior counsel for the petitioner submits that the matter is urgent in as much as it relates to deferment of an special recruitment
Yes.
drive, and therefore a week's time may be granted to the respondent side to seek necessary instruction. After considering the submissions made by learned counsel for the petitioner, the respondents are granted a week's time to file their affidavit in opposition and
2 weeks, Your Lordship. Wait for
seek necessary
Yes.
instruction in this regard.
Yes, because instruction is, that is the order. Lordship.
Let us give them 2 weeks time.
Mother, let it be on the 10th of April.
Is it okay? 10th of April.
Yes.
Let this matter be listed again on 10th of April.
Lordship, let my assisting juniors, their name be reflected in the cost list.
The registry to reflect the name of Mr.
My assisting juniors, there are others also, Lordship.
the councils assisting the senior counsel for the petitioner in the cause list henceforth.
Obliged, Your Lordship.
Item numbers 3 and 4.
Today we are on criminal appeal 1 of 2025, where my learned friend had filed an application for objection. Before your lordship proceeds with the criminal appeal 1 of 2025, may I show the order that has been passed by your lordship in criminal revision?
No, whether appeal is for
IA.
IA,
Yes.
so a
IA.
separate IA has been filed.
Yes, objection has also been filed.
Criminal IA 4,
Yes, correct.
IA 4.
Yes. My lord, there is a connection with the criminal revision petition 3 of 2025. So if your lordship takes the order passed by this court, order on 21/3/2025, in criminal revision petition 3 of 2025.
Yes.
I just read the order, my lord. That has some live connection with the criminal appeal. Kindly see paragraph 2. Paragraph, it will start from paragraph. It will start from paragraph. See kindly paragraph 10. Paragraph 10. Paragraph 10. The learned senior counsel for the petitioner has submitted that as the non-bailable warrant of arrest issued in pursuant to the order passed in IA number 230 of 2024 has been kept in abeyance, and as the personal appearance of the petitioner was dispensed with by the trial court on 18/10/2024, there was no occasion for the trial court to issue non-bailable warrant of arrest on 13/12/2024. This is very relevant. Hence, he prays for staying the operation of the impugned order dated 13/12/2024 till the next date, and also prays for keeping the warrant of arrest issued against him by the impugned order in abeyance till the next date. Now, 11 is most important. Considering the submission made by learned senior counsel for the petitioner, the learned special public prosecutor has submitted, since the ED has sought for time for filing written objection against the revision petition, he has no objection to grant of interim relief sought for. 12. Considering the submission made by learned senior counsel for the petitioner, prima facie it appears that order dated 5/9/2024 has not been violated by the petitioner. Hence, till the next date fixed, the operation of the impugned order dated 13/12/2024 shall remain stayed, and a non-bailable warrant of arrest issued in pursuance to the impugned order shall also remain stayed till the next date. So what your lordships, the matter which was moved before this court was pertaining to an impugned order of 13/12/2024. Now that order was put to challenge by revision application, revision petition. Now that, what was that order? Just recollect that order. It was violation of order of 5/9/2024. Your lordship, personal appearance, there was a violations. So the court said, the court on 13/12/2024, without going to the full orders of 5/9/2024, where later part it says that 230 application which was filed by them, IA 230 of 2024, there was a specific order, the warrant of arrest will be kept in abeyance, 5/9 later part, and the IA 230 of 2024 has been recalled. That order has been recalled, and a chance will be given for re-hearing of the matter. So, and personal appearance was dispensed till 18/10/2024, which is the next date it was fixed. Now 18/10/2024, when my particular date was fixed, that also, that date the personal appearance was also exempted on 18/10/2024. And my lord,
What is the next date fixed after 1810?
18/10, the next date, 12/12, it was fixed. 12/12, it was fixed. And thereafter, the 12/12/2024, the ED lawyer was absent, and the court said that we will hear the IA 230 of 2024 and IA 791 of 2024 on 13/12/2024. So 13/12/2024 was put to challenge by criminal petition, which has moved on the last time, and there was an interim order. Why I am now saying there is a live connection with the.
But whether 230 has been heard,
No, it is not been heard. Till date, it has not been heard.
when the next date is fixed?
Net date is fixed. It has. This is, we will take instruction when the next date is fixed.
But
PD,
230
you know, the next date. Trial court. Because in the meantime, what has happened?
by order dated 5/9/2024,
Yes,
the order of 230 was recalled,
yes,
and it was directed that it will be reheard after giving you an opportunity.
correct, right.
But it is yet to be heard.
Yet to be heard.
So the question of issuance of non-bailable warrant.
Could not have arisen at
Okay.
all.
Okay.
Now, if that be the case, now which is most important, has a connection with the present criminal appeal. My lord, what has happened? Dates are important. If your lordship looks into the date of the criminal appeal, kindly take the criminal appeal. And if your lordship looks into the at page 36,
Of the criminal appeal.
criminal appeal, we are on criminal appeal.
Your worship, to this here fixing for hearing IA or one of the or not the criminal
Yes.
appeal.
We are hearing IA only.
Yes, your lordship is hearing, but I have to show that.
Yes.
Your lordship,
At
when
what
an
stage,
injunction,
what stage criminal? appeal?
injunction application is
In
heard, I have
criminal
to
appeal, you will be filing some,
they have filed, already
have
filed.
filed.
I'll show you.
they have filed objection in the IA.
Objection, no.
IA.
Plus, not only IA, they have given a parawise reply in respect of this criminal appeal. I'll show it.
But we are not hearing criminal.
No,
appeal.
your lordship is hearing about the IA.
Okay.
But for hearing about the IA, I am praying for an interim. Your lordship has to see what was the order that is passed. Why I'm saying, your lordship will kindly note the date where they filed the application for declaring me as a fugitive economic offender. That please note the date, that is 24/10/2024. That is the date where, that is the date where they have filed this application under section 4 by the ED on 24/10/2024. Kindly see that, it's very important. IA 791 of 2024. This is very important, this date. My submission would be, my lord, first, the date which they have filed on 24/10/2024, IS 791 of 2024, under section 4 of the Fugitive Economic Offender. That particular, if your lordship looks into, if under definition,
No warrant was there.
no warrant that was pending on 24/10/2024.
Because
So
warrant was issued on 13/12 only,
that's right.
and 230 was kept in abeyance.
Correct, my lord. If so, there was no occasion of the application to be filed. It is a premature application. They could not have filed that application. Where is the question of
When the non-bailable warrant under 230 was
recall?
issued.
Non-billable was 2/7/2024. 2/7/2024. And that particular was stayed on 5/9/2024. Recalled. It was kept in abeyance, non-billable, and the order of 230 of 2024 was recalled by order dated 5/9/2024. This is the case, man. If that be the case, and the 230 will be heard, that lordship has seen the operative portion. Now, if that be the case on 5/9, so it has been kept, which has been on 18/10/2024, the 5/9/2024 merged with the order dated 5/9/2020, 18/10/2010 merged with 5/9/2024. Now, if that be the case, my lord, on 24/10/2024, where is the occasion to file an application under section 4 by the ED for declaring the petitioner as a fugitive economic offender? At that day, my lord, the warrant, there was no pending warrant. So that application is premature. You could not have filed. Forget about the order. Now, I will try to submit before your lordship that, let us say, for an argument's sake, that warrant is pending. Let us, for an argument's sake, even, my lord, I will show the order in which manner, with a great respect, the learned special judge has passed the order. My lord, learned special judge has overlooked, which is most vital, section 10 of the FU Act. He has overlooked, completely has overlooked. So there are two arguments which I am going to advance. First, 24/10/2024, the application could not have been filed. It is clear. That's the end of the matter. If your lordship is prima facie, your lordship, on record, I am saying, it is not that something on record. 18/10/2024, 5/9/18/10/2024. Now 24/10/2024, the next date, my lord, has been fixed on 12/12/2024 and on 13/12/2024. Till 13/12/2024, where is the occasion that on 24/10/2024, the order, the application ought to have been filed by them? Where is that? Now, for the convenience, your lordship will kindly see the list of dates in criminal appeal. That will be easier for your lordship. Kindly see the list of dates. That makes it more easier. Page number 4, my lord. List of dates. Oh, very beginning.
Yeah.
Yes, list of dates. Lordship will kindly see. Lordship got it, list of dates.
Yes, list of date.
So I think, my lord, once we go to the list of dates, that makes more easier and convenient. My lord will kindly see 18/10/2021. FIR registered as Cyber Crime Police Station, Kohima, FIR so and so. Understand? So this is the main FIR, which is a predicate offense. Now 12/4/2022, investigation initiated by ED under PMLA, so and so. 22/3/2024, complaint was filed by ED before the learned special judge, Dimapur, Nagaland, under section 4, against the petitioner and 298 others. 22/3/2024, learned special judge took cognizance of the complaint dated 4/3/2024, being registered as PMLA 1 of 2024. So my lord, 22/3/2024 was the first date where the cognizance was taken. 22/3/2024. Now, next date was 24/5/2024. Appellant entered appearance in PMLA and was represented by engaged counsel before the learned trial court. Relied upon documents were supplied to the learned counsel for the appellant in the form of a pen drive. And the next date was fixed on 2/8/2024 for argument on charts. Now, if your lordship kindly look at 2/7/2024. This is a date, 2/7/2024. Respondent filed a petition IA 230 of 2024, inter alia praying for issuance of non-bailable warrant against the petitioner. The learned trial court was inter alia pleased to allow the prayer of respondent IA number 230 of 2024 and was further pleased to issue an open-ended non-bailable warrant of arrest against the appellant in his absence. 2/8/2024. My lord will kindly note down 2/7/2024 was not a date which was fixed by the court. It was an off date which this petition was filed. 2/7/2024. Because next date was fixed on 2/8/2024. If your lordship looks into 24/5/2024 order. Kindly see, next date was fixed on 2/8/2024 for arguments. So on off date this application was moved. 2/8/2024, petitioner represented by learned counsel, whereby learned counsel filed two petitions, being IA 506/2024 dispensing with the personal appearance of the appellant and IA number 507 of 2024 for allowing appellant to appear before the learned trial court through hybrid mode. Learned trial court was inter alia pleased to allow the IA number 506/2024 exempted the personal appearance of the appellant for the date before the learned trial court. Learned trial court further inter alia pleased to fix 27/9/2024 are arguments on IA number 507 of 2024. 5/9/2024. Learned trial court was inter alia pleased to pass an order on IA 531, that recalling of that particular 230, 2024 filed by the appellant, whereby IA number 230/2024 was directed to be reheard, thereby keeping the non-bailable warrant of arrest in abeyance that was issued against the appellant wide order dated 2/7/2024, passed in IA 230 of 2024. 27/9/2024, respondent filed objection in IA number 507 of 2024, and the next date was on 18/10/2024 for arguments. 18/10/2024, learned trial court exempted the personal appearance of the appellant for the day, and the next date was fixed on 12/12/2024 for hearing on IA number 230 of 2024. Learned trial court was further pleased to continue the interim order dated 5/9/2024, whereby the non-bailable warrant of arrest was kept in abeyance. Further, the learned special PP also submitted before the learned trial court that a copy of petition being IA number 230 of 2024 will be served on the appellant, to the appellant on the same date. The next date of the business was fixed on 13/12/2024. Now, please mark the next date, 24/10/2024. That is again an off date. 24/10/2024. Case record was put up along with IA 791 of 2024, filed by the respondent inter alia, praying for a declaration of the appellant as a fugitive economic offender under the provision of the Fugitive Economic Offender Act 2018. The learned trial court was pleased to fix 12/12/2024 for reply and further hearing on IA number 791 of 2024. Now, my lord will kindly see, this is 24/10/2024 is my lord, the case where now I am moving before this court, where I am aggrieved by the application which they have filed also. Now, kindly see 12/12. Learned engaged counsel for the appellant prayed for time to file a reply in IA 791 of 2024. Matter was fixed on 13/12 due to non-appearance on the principal counsel of the respondent. Now, 13/12. The learned trial court inter alia pleased to allow 1 week's time to appellant to file his reply. IA 791 of 2024. Learned trial court, while rejecting the application for exemption of the personal appearance of the appellant 40 days, as well as rejecting So as well as overlooking the proceeding recorded in the respective order dated 5/9/2024 and 18/10/2024 was inter alia pleased to order execution of non-bailable warrant of arrest which was issued earlier by order dated 2/7/2024 in IA number 230 of 2024.
This order you have come again in the revision.
Yes. So if this be the case, 2/7/2020 IA 2030 was recalled by the learned court, and the learned special judge has said, yes, we have to recall that order. Because that was an ex parte order. 531, we filed for recalling of that order, and it was recalled, and non-bailable warrant was kept in abeyance. And my personal appearance was dispensed, and IA 230 of 2024 will be reheard. Now, what would be the appropriate case of the ED that they should have waited? They should not have filed at 24/10/2024 update for declaring me as a fugitive economic offender. At least 230 of 2024 should have been heard. Then only they could have proceeded. They did not proceed. On 14/1/2025, learned trial court was pleased to hear the argument of both sides in IA 791 of 2024, and the order was resolved. And 22/1/2025, this is the impugned order, man. The learned trial court pleased to partially allow the prayer of respondent made in IA, thereby declaring the appellant as a fugitive economic offender under the fugitive so and so 2018. So 22/1/2025 is the order which were put to challenge. So, my lord, the fact remains that on 24/10/2025, 24, my lord, the application which they have filed, there was no pending warrant. So, my lord has not to go to other aspect of the matter. That itself is, they could not have filed that. And the learned trial court could not have issued that order. Filing the application, the pending warrant. The learned trial court, the special judge court, the PMLA should have said, no, you wait. Where is the question of filing the application IA 791? Because 230 has been recalled and I will hear it. But the warrant has been kept in abeyance. Time has not come. We'll hear that 230, then my lord will proceed. Now kindly see the order that has been passed by the court and which has been put to challenge. It starts from page application, kindly see, which is the application they have filed before the learned trial court. 791 is page 54. Kindly see page 54. The application which they have filed.
Yes.
My lord, I will just try to show before this court, before going to their application, if your lordship looks into before their application, it will be easier to connect. If your lordship takes the act.
Now, what will happen to the appeal? For in the appeal, for what, at
We have-
what stage appeal is pending?
I'm sorry.
The appeal which you have.
No, we'll
deferred.
give a reply. They have to give a reply, but reply they have, what I find, the reply has also been filed.
In the IA,
IA itself.
but in appeal,
Appeal, they have not, they dealt with the appeal also. I will show it. I will show it, my lord.
no, whether you.
I'm sorry.
Disposing of the interlocutory application would amount to disposing of the appeal itself.
No, it will not happen.
No.
Because temporarily your lordship is
Then
going.
we will admit the appeal.
And my lord, temporarily your lordship will stay this order. The appeal, the IA, we have prayed for interim order. They're praying for interim order because in the meantime they have declared me a fugitive economic offender. What is more dangerous? Declaring me as a fugitive economic offender.
No, why appeal cannot be heard today?
Where? Appeal.
Yes.
Appeal can be heard, my lord. That's a small issue here because today your lordship has fixed for IA of 2024. Your lordship has fixed. So what I'll pray, my lord, there'll be no prejudice. Why I'm saying, my lord, but There is no problem, my lord. Your lordship can give time to file. That's a no problem. But we are on IA. Kindly see the
No,
IA.
no. My query is the hearing submissions which you are making in IA
Yes,
would be same in appeal also.
yes, yes. It will be
Because
same.
point to be determined is a limited
Yes,
issue.
yes. It will be almost same.
So why appeal cannot be heard today, Mr. Special Public Prosecutor?
No, it's up to them.
Regarding about appeal 125. Yes, the court have granted that we are yet to file affidavit in law.
You will be filing some
But otherwise, they will say
in
Oh,
that
appeal.
my time was not given. Again, I am concerned.
No,
of-
in the appeal, is there any provision of filing objections?
My lord, I don't know nowadays, earlier those days, there is in criminal
Because-
case, I have not come across that affidavit as to file.
Yes,
My lord, now with great respect, I am saying, when I started, when I was assisting with J.M. Chaudhary, those great criminal lawyers, we were used to say, let us file. What affidavit is to be filed in criminal petition?
yes, that is my,
It's on record, nothing is there to file. Now, my lord, with great respect, the affidavits are being filed in criminal case also.
because in appeal,
Yes.
against their memo of appeal, whether records have been called for. Records have been called for,
Which I'm sorry, my lord.
like records of the,
I have to call for.
whether records would be required.
My lord, what I will just propose, my lord, subject to your lordship and my learned friend. My lord, let the records be called for in this case, because criminal appeal, your lordship has to see the records. And in the meantime, the order that has been passed, 22/1/2025.
Appeal, we will admit for hearing.
Yes.
We'll admit the appeal for hearing, calling for the record and fix a next date. Then we can continue with the IA.
No, IA is, my lord, otherwise, the problem is not the declaring me as a, and confiscation of property, that's the problem. There are two things. One is declaring me as a fugitive economic offender and confiscation of property. Now, my lord knows, in a PMLA case, till the trial, we don't know what will be the outcome of the trial. They may put for auction, then it is gone, my lord. That's the whole problem. That's why I am before this court. Before trial, they will put on auction. Then what I will do it, my lord? Even it is appeal or the trial, my lord, it is in my favor. I will never get this property. And how the order has been dealt, kindly look into it. How
Okay,
an order
okay.
has been dealt.
Let us go through the.
Yes. My lord, before that, if your lordship looks into this will make it more clear before going to the order. Kindly take the act, my lord. Then it will be very easier. How with the great respect, the learned trial court, the error has been made. My lord will kindly see 2F. 2F first.
Yes, fugitive economic offender.
My lord, fugitive economic offender means any individual against whom a warrant for arrest in relation to a scheduled offence has been issued by any court in India who has left India or to so and so, so and so. Now we are definition. Issued by the authority concerned. A valid warrant has to be kept pending. Now see chapter 2, next page, where an application under section 4 has been filed by the ED. See section 4, my lord. Next page.
Yes.
So this application under section 4 was filed on 24/10/2024. That is IA 791 of 2024. Now 4.1, where the director or any other officer not below the rank of deputy director authorized by the director for the purposes of this section has reason to believe, the reason for such belief to be recorded in writing on the basis of the material in his possession that an individual is a fugitive economic offender, he may file an application in such form and manner as may be prescribed in the special court that such individual may be declared as a fugitive economic offender. So, fugitive economic offender is defined under 2F.
Yes.
So now, my lord, will kindly see, if you file an application under section 4 before the learned special judge court. Now, yes. So 2F, a fugitive economic offender, my lord, that has to be looked into by the court. That whether under 2F, whether the warrant was pending or not, that was the first thing that court should have ought to have looked into it, which the court has not looked into it, with great respect. So that is the first. The ED should have come forward and satisfy before the court that the warrant was pending. Then only it's a case of declaring fugitive economic offender under 2F. This is the first, which is most important. That was not there. Because on 24/10/2024, when they filed that, at that day, that warrant was not pending. So first argument, where is a question of declaring me as a fugitive economic offender? Now next, kindly see. So this will be the first argument, my lord, before this court.
Okay.
So if it is a 2F, I don't fall under definition of 2F, my lord, that's the end. Then the application could not have been filed. It is a premature application which they have filed under section 4 before the learned special judge. So where is the occasion of filing this application? 24/10/2024. So now, my lord, this is the first. Now let us see what will be the second argument. Advance. Now for a time being, even as record, the warrant was there was no warrant. Let us say if the warrant was pending, then what would have happened? If warrant would have pending, then what would happen? Then whether on the basis of the application which has been filed under section 4, whether there was a compliance, which is a mandatory compliance under section 10 by the learned court, was done or not. That has to be looked into by the court. So now the 10 is a procedure which has been laid down. If your lordship looks into 10, see 10, my lord.
Yes.
Kindly see 10.
Yes.
10.1, where an application under section 4 has been duly filed. That is on 24/10/2024. The special court individual who is alleged the first, whether a notice has been issued to the alleged fugitive economic offender. Now number 2, now number 3, kindly see. 3 kindly see. A notice under subsection 1 shall A require the individual to appear at a specified place and time not less than 6 weeks from the date of issue of such notice. My lord, when a notice is issued, it has to be reflected. Now, if you look the order which has been passed, there's no notice. All this procedure has been violated. This is a procedure which has been laid down. That is why I'm saying, my lord, first argument, there is no pending warrant. Argument sake, let us say there is a pending warrant. Even the procedure because these are draconian law, procedure has to be followed. Now, this procedure, I will go through the order, my lord. All this procedure under section 10 was not followed. Notice has to be issued. Now, if notice is issued, that is not also enough. Specified place and not less than 6 weeks from the date of issue of such notice. And B, kindly say, state that failure to appear on the specified place and time shall result in a declaration of an individual as a fugitive economic offender and confiscation of property under this act. Now, my lord, what it says, a notice to be issued. By the court has to issue this notice. Now, once the notice has been issued by the court, my lord, they have to specify the place and date, and this period is not less than 6 weeks. Now, suppose he received notice, even then he doesn't appear. Then what happens? B, my lord, state that failure to appear on the specified place and time shall result in declaration of an individual as a fugitive economic offender and confiscation of property under this act. So these are the most important essential part of the particular to decide an application under section 4, and 10 has to be mandatory followed, has to be followed by the trial court, which has not been followed by the court. These are very important. That's why I said, my lord, this order itself, my lord, has no legs to stand, this order. How an order, my lord, it's so important. Somebody has an update and filing an application under section 4, and the learned trial court with great respect has not followed section 10. Now kindly see 4, my lord. See, kindly see 4. A notice, kindly see 10.4. A notice under subsection 1 shall be forwarded to such authority as the central government may notify for effecting service in a contracting state.
What is this contracting state? Means,
Maybe a foreign country, maybe a contracting state. Maybe a
Because
Dubai
it's
can be a
okay.
state, contracting state. Maybe not necessary. That will be given to an embassy. The embassy, because he may be in Dubai, so it can be given to a contracting state. So there are some countries which has a signatory with the India bilateral ties. So there are certain countries which have got a bilateral ties with the India yes. So now if your lordship looks into it, 5, the authority referred to in subsection 4 shall make efforts to serve the notice within a period of 2 weeks in such manner as may be prescribed. Here also, my lord, it says authority referred to in subsection 4 shall make effort to serve the notice. Who is the authority, my lord? Once the notice has been served to the contracting state, that contracting state shall make an endeavor to serve the notice within a period of 2 weeks in such manner as may be prescribed.
in this case, no notice was issued at all.
No notice was issued.
So other things will,
Correct. That will automatically. This is most important. No notice. Yes.
okay.
10.2 kindly see, my lord. 10.2 also. 10.2 is also important. The notice referred to in subsection 1 shall also be issued to any other person who has interest in the property mentioned in the application under subsection 2 of section 4. Not only that notice has to be issued only to the individual, that is to the petitioner, it has to be also notice has to be issued to any other person who has interest in the property. Also is important, my lord, shall also be issued.
Okay.
Contracting state has been defined, my lord. Kindly see 2C. 2C has been defined. Contracting state has been defined. 2C, my lord.
Country or place.
Contracting state means any country or place outside India in respect of arrangement has been made central government with the government of such country through a treaty or otherwise. That's a contracting state. So 10.2 is also important. Why I am showing 10.2? This, when you read the order of the learned trial court, what he has done, my lord, for a time being 10.2 has been kept. He said, no, 10.2 will issue notice later on. Will first issue to that individual the petitioner. Now, the learned trial court cannot leave 10.2. 10.2, the notice referred to in subsection 1 shall also be issued to any other person who has any interest in the property mentioned in the application under subsection 2 of section 4. So my lord will kindly see the application which they have filed. Now it becomes easier, my lord, kindly see the application which they have filed. The ED which they have filed. It starts from page
54.
Yes, 54. This is the application they have filed. IA kindly see 791 on the top, 791 of 2024. This is the application they have filed. Page 55 is important. Kindly see 55. List of interested persons. So that is why I was reading 10.2. That is why I was reading 10.2.
So before declaring a person fugitive as fugitive economic offender, notice shall have to go to all these interested persons.
Correct, absolutely right. You cannot declare only their individual pickup and he will exclude that 10.2. That cannot be done. So you have to read harmoniously 10.1 and 10.2 also. It is no question of that you have to read 10.1 and 10.2 will exclude. You can't. So this list of interest person, you kindly look into it, my lord. From 1, serial number 1 to serial number 65. See 55 to page 65. Demand percent total 179%.
These have interest in the property of the,
Yes, ED. So ED has filed this application. ED has filed this application. List of interested person. So this is the, my lord, the only an allegation that will again, these are list of interested person. So this is a application filed by ED. So up to page 65, 179. Now brief facts of the case. Now please see 118, my lord, the prayer portion. See, we'll get the facts and everything. My lord, procedure not follow, that's end. See page 118, my lord, the prayer. See the prayer. See the prayer at page 118.
yes.
Issue a notice and envisaged under section 10 of the fugitive economic offender requiring the accused person Bhupesh Arora so and so before so and so. And kindly see, and also, my lord will kindly mark, and also issue notice to the interested person. What you got it? So one is so under section
Last
10.
line.
Yes.
Okay.
So 10, my lord, to the individual.
They had prayed for issuance of notice.
Yes. And also, my lord, issue notice to the interested person. So their prayer is under section 10 to be declared a fugitive economic offender. Not only the individual, notice has to go to other interested person also.
Okay.
So now, my lord, this is the prayer they have filed. Order kindly see. At 147 is the 142 is the starts the order. 142 is the order. Which starts from 142. 142 and see 143, my lord. First first paragraph is important. 143, order is 22/1/2025. See number 1. The instant IA pertains to an application under section 4, read with section 10 and 12 of Fugitive Economic Offender Act, seeking declaration of the accused respondent as fugitive economic offender and confiscation of property. See, my lord, declaring and confiscation of property. Now, my lord, both the counsel heard. See at page 147. Now see at page 147, paragraph 8. Paragraph 8.
Yes. Yes.
In regard to the requirement, as specified in the above referred provision of FEO, the trial against the present accused person is pending before this court for offences under section 3 of PMLA 2002, read with section 4 of PMLA 2002, which is scheduled offence under section 2 and 1M of FEO Act 2018. Further, this court has issued open-ended non-bailable warrant of arrest, wide order dated 2/7/2024 against the Bhupesh Arora, while disposing IA 230 of 2024. Thereafter, on 2/8/2024, the presence of the accused was exempted and wide order dated 29/8/2024, a non-bailable warrant of arrest issued against the accused kept in abeyance pending hearing of the application filed for cancellation of the said warrant of arrest of the accused. Thereafter, wide order dated 5/9/2024 by my learned predecessor while disposing of the application IA 531 of 2024 for cancellation of non-bailable warrant has kept in abeyance the non-bailable warrant till the next date and passed order for hearing of IA of 230 of 2020, which is admitted by the order. This court, while order dated 18/10/2024 and 13/12/2024, has granted extension of the order to keep the non-bailable warrant in abeyance. In this regard, learned defense counsel stated, your lordship will kindly skip this. And now, these are the argument which is advanced. 152, kindly see now, my lord. 152. Before paragraph 15, at 152, before paragraph 15, one paragraph. Further, during the hearing of this instant application, the applicant complainant has only pressed for declaration of the accused as fugitive offender, and as such, notice as required under section 10(2) of the FUO Act at this stage since not been pressed by the complainant applicant. How they can do it? They can't say that no, I will not press 10(2). ED can't say I will not press 10(2), I will only press 10(1). Your lordship has read this, the provision of the section 10(1) and 10(2). It is mandatory, shall also. Applicant, this court reference, my lord will kindly see now interesting. Since not been pressed by the complainant applicant, this court refrains from discussing on that aspect. How, my lord? How it can be refrained? It is a very important issue. As such, the proceeding for confiscation of the properties of the interested person listed in the application shall follows suit. The matter is left for further consideration. This itself is illegal. So how can you decide in part? One decide, will say 10(1) will decide, 10(2) will decide later on. That is not the object of the act. That's not a procedure laid down under section 10. You cannot violate section 10. No. Now kindly see 153. A. Application in terms of part of prayer clause 2. 153.
Yes.
Application in terms of part of prayer clause 2 for declaration of respondent as fugitive economic offender under section 12 of fugitive economic offender hereby allowed. Now, my lord will kindly see what is 12. Kindly see 12 because referring to 12 of FUO Act. 12. Kindly see 12.
Yes.
12 is after hearing the application under section 4, if the special court is satisfied that the individual is a fugitive economic offender, it may by an order declare the individual a fugitive economic offender for reasons to be recorded in writing. On declaration under subsection 1, the special court may order any of the following property stands confiscated to the central government. My lord will kindly see 14. Kindly see once 14. Because they are taking the help of section 14. 14 has no connection with this criminal case, my lord. Kindly see 14. Notwithstanding anything contained in either law for time being in force. A. On declaration of individual a fugitive economic offender, any court or tribunal in India in any civil proceeding before it may disallow such individual from putting forward or defending any civil claim. And B. Kindly see B, my lord. Any court or tribunal in India in any civil proceeding before it may disallow any company or limited liability partner. This is, my lord, of course not come. So they have taken the records of 14. 14 has nothing to do. It is civil claim. And NC 17, my lord, 17.
What 14 says that if a a person is declared as fugitive economic offender
Yes.
and his property is confiscated,
Yes.
then with regard to that property, if there is a civil case,
Yes.
he cannot raise his defense.
That's the whole issue. That is why today you confiscated, they may be so draconian that you don't follow the procedure and you confiscate and you auction it. You auction it because I cannot go for civil court. Once you auction it, what I will get it? If tomorrow if the trial is I am acquitted, can I get the property back? That is why I am coming before this court. Not only the confiscation of the property also I have come up. That is why I file an IA. You can't do it. Their whole intention, motive is only to auction it. Confiscation of property. So that is why they made so hurriedly, my lord. All the application is an update. Kindly see, my lord. They are saying that you have not committed clearance. What about you? You have not committed clearance. Why not update you are filing all this application? Now kindly see 17. See 17. 17, my lord. Appeal. My lord, see the appeal, the provision of appeal. An appeal shall lie from any judgment and order, not being an interlocutory order of a special court to the High Court, both on facts and law. Every appeal under this section shall preferred within a period of 30 days from the date of judgment order appeal form. So we have come within the time limit. Provide a High Court may enter appeal after. So that is why we file an appeal.
This is not an interlocutory order.
Correct. This is not an interlocutory. It's a final order. You declare me as a
Declaring
fugitive economic offender.
Okay.
My lord, I think, my lord, on the face of it, it is absolutely out and out, my lord. This is not a error that has been made by the learned trial court. With great respect, I will say to the learned trial court. First, my lord, the learned trial court argument is you could not have, the learned trial court could not have entertained this application. 791 of 2024 could not have been entertained. On 24/10/2024, that warrant was not pending. So once you make an application under section 4 by the ED, the learned special judge could have said, please do not file this application. 230 of 2024 we have recalled. It is pending. Warrant has also been recalled. Personal appearance also be exempted. So you file after deciding 230. And second argument will be that itself goes. Second argument, even assuming for an argument's sake that this warrant is pending, you violated all the procedures under section 10. That's my humble submission. So what my prayer is that criminal appeal, my lord, can admit this criminal appeal. In the meantime, my lord, I pray for a stay of that order because it's so draconian. Tomorrow they will auction it. That's the only difficulty. Otherwise, what I would have said, my lord will admit it. We'll hear it, this matter. So we came running and filed this appeal. Revision, we filed it because we have to. That is why we said that it has got a live connection. Now they have taken a stand in their IA. Objection has also been filed by them. Because in this case, the wife has filed an affidavit. Affidavit has been filed by the wife of the petitioner.
This appeal has been filed by
The appeal has been filed by the wife, affidavit has been shown, and the wakalanama has been filed by the petitioner. That is absolutely, they have said that no, this application cannot be entertained. How it can be entertained? This is their stand. I am taking, my lord, they have taken that one stand is this. Because before my learned friend starts, I'll just counteract what he says. One, he has taken a stand. This is not maintainable. Why it is not maintainable? Because wife has filed this affidavit. Now the question is that whether wife cannot file this affidavit.
No, whether wife has filed the affidavit or the appeal.
Affidavit has been filed by appeal. Yes. But here, my lord, affidavit is required in the principal seat. I think in an appeal, my lord, the certificate is required. In criminal appeal, certificate is required in the principal seat. But here, my lord, an affidavit has to be sworn also.
Appellant name has been shown as the,
Bhupesh
Bhupesh
Arora,
Arora.
yes. But the affidavit has been small.
what is your submission?
Mine, I will take, straight away, I have got a judgment. Submission, I have got a judgment, I will show the judgment, which is decided by this court. I know that will be the first point they will take it. So I was prepared, that is a division bench of this court. You don't know. Paragraph 12, kindly see that. See paragraph 12. It has been decided. Paragraph 12, my lord, will kindly see to the point.
Yes.
12. May we point out that as per note to rule 7 of chapter 6 of 4 of Gauhati High Court rules, affidavit has to be a person having cognizance of the facts. In Webster 28th century dictionary, the meaning of the word cognizance given, which is relevant for our purpose, is the fact of being aware, participation, knowledge. In Chambers 20th century dictionary, the meaning given is knowledge of notice. It is apparent that as advocate clerk would not be such a person. We would therefore hold that an affidavit enclosed with a writ petition containing allegation of malafide has to be verified by a person having direct knowledge of the act, constitution, malice in fact. As to the other type of petitions, my lord will kindly, which is in this case, affidavit should be verified either by the petitioner himself or by anybody else who is fully posted with the facts and circumstances of the case. We would or not regard as advocates class as such a person. The necessity of affidavit by a proper person lies in the fact, after all, a writ petition is entirely decided on the basis of affidavit filed by the parties, and as such to assure that minds of the court about the correctness of the averment made, it would be justified in asking an affidavit from a person having full knowledge of the facts of the case. The normal rule of giving the best evidence which is applicable in case of civil suit and criminal trial should apply. According to us, writ petition as well as the order shall apply to limit to file after 2 weeks. So it will apply to civil, all the case, it will apply. Yes, any other, as to other types of petition, whatever seen, as to other types of petition. So this is a law which has been laid down by our High Court, by a division bench. So they cannot take a plea that this is not maintainable. So this goes. Another point they have taken, my lord, Your Lordship, they have said that we've been hunting, bench hunting. I am sorry to say that what is bench hunting?
Bench hunting means?
Bench hunting means what?
In what
It's
context?
a very word, a loose word has been used.
In
Is
what-
like,
In what context? they
yes,
have?
in context means, if you see, my lord, we have filed a number of petitions before this court
Okay.
in earlier round of litigation. Like we filed 3 of 2024, 23, challenging the predicate offense adjudication proceeding. 3, challenging the adjudication proceeding, where a notice was issued under section 8. Under 8, which they want to attachment. We came up and filed an application before this court. Another application we have filed is under section 6 we have filed. Writ petition criminal 6 we have filed challenging the FIR of predicate offense. So there are 1, 2, 3 cases has been filed. Now all these cases they are saying that thereafter we decided to withdraw it. We decided to withdraw it. That doesn't mean a hunting, bench hunting. Now my lord will kindly see their affidavit which they have filed. See at page 4 of their objection to IA, paragraph 4. Kindly see their paragraph 4. Para 6 kindly be seen. Their objection.
Yes. They have given the list of cases filed by.
Yes, correct. Kindly see that it is submitted on the top. It is submitted, petitioner is the habit of forum hunting. What is forum hunting? Something is very ridiculous word has been used, forum hunting. I am taking a chance. That means I don't get an order, meaning that I'll tell my lord in a word, you don't get an order from a particular judge, you go and hunt and get an order from another judge.
That is what.
This is
meant.
what I understand. This is what is done in this case? Absolutely not. Absolutely not. If that be the case, I would not have accepted this case, my lord. At least that particular, my lord, I am there. I will not accept this case. If I see there is a forum ante, if the client comes to me, I say, sorry, I will not accept your case. Filing a case one after another is not a forum ante. Forum hunting is a very bad word. You try to get an order from a particular judge, you don't get it. You then go to another judge, get that order. That is forum hunting.
Yes.
Now kindly see para 8. What is the para 8? Page 6, para 8. These are all list of cases which has mentioned. Para 6, kindly see, now. Suppression, I don't know what suppression of material fact. See, para 6 at page 6, para 8. That the present petitioner has suppressed the material fact that FEO proceeding was pending before the learned trial court when he appeared before the Honorable High Court in WPC 26 of 2021. That was WPC Criminal 26 of where we challenge the complaint, questioning of the complaint. This fact has been brought out in para 7 of the reply filed in WPC Criminal 26 of 2000, which is pending for adjudication before the Honorable High Court, as the petitioner not approached with clean hands, therefore he is not. What is this?
No,
my-
but that WPC is not before us.
No, it's not
We
before
are-
this court. Well, let us say that it is before. WPC Criminal 24 of 26 of 24 is relating to question of a complaint which has been filed. Where is the question of this is a separate proceeding. Today we have come up, where is the question of declaring their FEO? That is an entire complaint has been for questioning of the complaint. Like a charge sheet, we come for challenging the charge sheet. Now kindly see 9, para 9, that the present application file in has been filed in limine with section 14 of the FEO. Section 14 is reproduces under reference. Now, hello, we have
14.
section 14.
14 is only in
Civil
respect of
proceeding.
civil proceeding.
Yes. Now there is nothing. 7, if you turn to page 7, they have given a parawise reply to the appeal. This is what is the case about, my lord. What is the contention also, I made it very clear, my lord. Their stand. So this is my case, my humble submission before your lordship that this appeal may be admitted. If they want, they can file. Your lordship can give it 3 to 4 weeks, no problem. Independent, this order is apparently, my lord, with great respect, I'll say this is an error which has been made. Is absolutely as a wrong order, I'll say. And IA, kindly see what is a prayer we sought for IA. Kindly see the prayer in page 15, my lord. Page 15, my lord. It is therefore prayed at page 15.
Yes.
It is therefore prayed that your lordship would be pleased to admit this petition and also pleased to stay the operation of the impugned judgment order 21/2025 and all the constitutional order passed in so and so, so and so, so and so, whereby the applicant is declared as a fugitive economic offender with the meaning of section 21F and stay all further proceeding for learned principles so and so in ML case during the pendency of the appeal. That's my prayer. Ad interim orders in terms of the prayers above. So that is the prayer.
No, this ML case stay.
No, that is all, my lord, that is only a prayer. I will not pray also. What I am saying, let it only the order of 22/1/2025.
Yes,
that
that
should
you
be
are
stayed.
challenging.
Yes, of course, my lord. My lord, we make all 10 prayers. It doesn't mean that you will allow all the prayers. If that is, my lord, if your lordship stay, it will directly that 26 I am getting a relief. While pray, I will pray there if necessary. So
Yes.
that is my humble submission for this court.
Yes, Mr. Kedu.
May I please, Your Lordship?
Yes.
Your Lordship, before going into the merit of the case, the present applicant, who is the wife of the petitioner,
No, applicant, wife is not the appellant.
She's the
Appellant,
applicant.
she has only shown the affidavit.
Yes.
That is their
But-
submission. Appellant is Mr. Bhupesh Arora, but the affidavit is shown by the wife.
By the way, Your Lordship. Therefore, you know, there is no locus standi for a wife to file this revision 3 of 25, criminal appeal 1 of 25, and IF 4 of 25, Your Lordship. Your Lordship, the accused present, the petitioner, the present wife division, she is not an accused. And in criminal case, in criminal, Your Lordship, there is no legal error in criminal. Therefore, the accused, the present applicant, she had no locus standi to file this.
No, applicant is Mr. Bhupesh Arora. You go through their application.
No, no,
Who is the applicant?
criminal revision, page number 26.
No, we are
Yes.
taking up IA 4 of 2025.
Page number 17, A4 17.
IA 4, the applicant in the cause title, applicant's name has been shown as Bhupesh Arora. Only the affidavit has been shown by the wife.
Wife, Your Lordship.
So applicant remains Bhupesh Arora. Now, wife is not the applicant. That is a wrong factual submission.
She is the deponent who signed.
She is the
affidavit, Your
deponent of the.
Your Lordship.
On that, what do you have to say? That she
Lordship.
cannot swear.
Your Lordship.
Okay.
And is liable to be dismissed in all this criminal revision, criminal appeal, and idea of 4 of 24, Your Lordship.
Yes, anything?
Before I go in the merit of the case, Your Lordship, I just want to highlight the genesis of this pertaining of this case. You know, Your Lordship may kindly turn to the page number 106, criminal appeal 1 of 25.
106. Yes.
Before paragraph 32, 23.2, before, Your Lordship may kindly refer to page 105, serial number 23. Before I go through to 106. Serial number 25, may I read before Your Lordship?
Yes.
The reasons to believe that the accused is fugitive economic offenders. Cybercrime Police Station Kohima, Nagaland registered FIR via crime number 03/2021 dated 8 October 2021 for offense committed under section 420(120)B of the Indian Penal Code, 1860 IPC read with section 66D of the Information Technology Act against HPZ token. This FIR disclosed that the HPZ token was an app-based token which promised user large gains against investment by investing in mining machine for Bitcoin and other cryptocurrency, Your Lordship. Your Lordship, we kindly turn to page 106, 23.2.
Yes.
May I know? 23.2. Where is the above narrated material in front of police FIR and statements recorded during the course of investigations and various other materials collected during investigation clearly established that Liliant Technology PVT and the Shago Technology Private Limited were involved in operating and collecting money from investors in the name of HPZ's token and helped receive approximately 115 crore from the Gauhati public in the case of HPZ token act, and the money was further transferred to various entities, individuals. It may be noted that the Shago Technology Private Limited (STPL), along with collected proceeds of more than 172 crore from the Gauhati public in the case of unregistered gaming betting website apps Bupis Arora and his associate had control over Shago Technology Private Limited (STPL) and similar entities indulged in fraudulent activities and duping gullible publics. The algorithm in such apps website is designed in a manner so there is hardly any chance of an individual to win through analytic business venture. They have transacted more than 1,300 crore, and with SART enrolled system, private limited has made payoff 900 crore through various shells companies. Your Lordship. Your Lordship, before I go into IA of 1 of 25, may I allow to submit to counter about revision 3 of 25, which is all are inconsistent, all are in where the lower court, the special court has not committed any error, Your Lordship.
No, but we are hearing only IA4. Today,
Yes,
only IA4.
Yes, Your Lordship. Your Lordship, kindly criminal revision 3 of 25, page 61. Page 61.
Which point you want to emphasize?
Just below the seal, just below the round seal, Your Lordship, the investigation leader, just below the round seal. May I maybe right left side,
Yes.
just below the investigation, Your Lordship.
Yes.
The investigation revealed that at the behest of the accused, Bupis Arora, the deposited amount was further transferred to create untraced layer of transactions, since the owner of the entities involved in money laundering are situated outside of India, and it is reasonably believed that after several layers, the money through Halawa route are siphoned out of India, Your Lordship. Layer, untraceable layer, which means, Your Lordship, the amount routed through various bank accounts, or in short, this is called the payment gateways. And Your Lordship, in continuation, the money through Hawala routes are siphoned out of India, which means illegal channels money sent through abroad, Your Lordship. One of the allegations against the present accused is that the Phoebe Solutions PVT Ltd, which is an entity controlled by the accused, Bupis Arora had several transactions with SART Herald Systems PVT.
No, Mr. Kedubu,
Your Lordship.
we are not going into the merit of the case. Their case is very limited,
Yeah, Your Lordship.
that there was no occasion for filing of this application by you for declaring him as fugitive,
Your Lordship.
because on that day, the warrant of arrest which was issued was kept in abeyance.
Oh.
Second leg of submission is that procedural requirement as mandated under the Act, Section 10 was not followed. Therefore, the order of declaring him as fugitive economic offender and confiscation of his property is liable to be set aside or liable to be stayed. That is limited submission.
Yes, Your Lordship. Regarding about non-bailable issues of non-bailable rights, Your Lord, you may kindly turn page 62 of revision 3.
Yes.
Page paragraph 3, Your Lordship.
No, but this order is under review. This order which you are reading,
Your Lordship.
order dated 2/7/2024 in I-230. This is still pending for hearing. This has been recalled.
That's why for the clarification of this, Your Lordship, I just want to go in sequence accordingly in order to show that the level of awareness of issue by this special corridor. So I want to show that in sequence, not in round.
But matter remains that this fact remains that this 2/7/2024 order passed in 2/30 is have been recalled for further consideration.
Lordship, that's why.
So-
I just want to give a clarification because there is a connection with all these IA
Okay,
to 30, 531 and 791. All these are interconnection, Your Lordship. That's why I just want to give a brief
okay.
in order to.
Go ahead.
Yes, Your Lordship. Your Lordship, page number 62, Your Lordship. The
Yes.
appraisal of this ECR shows that there is a prima facie case against the accused Bukisan for the enforced as alleged against him. As submitted by the learned SPP, the record shows that the summons under section 52 clause 2 PMLA were issued to the accused on 6 days, but never appeared before the investigation official. Though he had responded via email to summons dated 23/2/23 and 18/2/23. Citing medical reasons and to the last summons dated 2021/2024, praying for a few weeks time. He never appeared before the IO, even the order of the 25/9/2023 passed by the Honorable Gauhati High Court at Kohima bench in repetition filed by the accused. WP Criminal 3 of 2025, where the accused was directed to cooperate with the investigations, was never complied with by the accused. For not complying in a court order, in a dishonorable court, and also failing to appear before investigation official. The special court, special judge has issued non-bailable warrant of arrest. Whereas the petitioners have filed to keep the evidence of this non-bailable warrant of arrest. You know, kindly page turn to page 41 of criminal review. 41. I get 531 between the three university in the operation part is that Mr. Amit, since that learned counsel for the accused petitioner prepared for keeping on abeyance the order dated 02/07/2024, issuing non-bailable of warrant to the accused petitioner till the next returnable date, Your Lordship. However, I am inclined to the said prayer, and as the matter is speaks, will be heard on merit, Your Lordship. And Your Lordship, based on this, the petitioners have filed another IF 521. Your Honor, can you reflect to page number 63 IA? Page 60 criminal revision, page 63, Your Lordship. Point number 2. The petitioner's applications under section 7(2)(2) BNSS is filed by the accused petitioner, Mr. Bhupesh Arora, paying for recording and or cancelling the order dated 02/07/2024, wherein a non-bailable warrant of arrest was issued against him, you know. And you know, kindly page 66, point number 5, Your Lordship. Since the accused person is not shown as an absconder, the honorable court have given an opportunity to heard. So you know, mechanically coming down to the last para, the applications. The applications of the ED will be reheard on the next returnable date, which is fixed on 18/10/2024. ED is to supply a copy of the application to the accused petitioner through counsel. Meanwhile, the non-bailable warrant of arrest issued against the accused petitioner, namely Bhupesh Arora, is kept in abeyance till the next returnable date. The accused petitioner is to be personally present on the next date, Your Lordship. And Your Lordship, mechanical page, turn page 43 of criminal revision. the last paragraph. That is the 18th/10/2024. The Learned Counsel Amit Shah since appeared for the accused number 1 has appraised this court that IA 230/24 is pending disposal whereby the complainant has filed for NWB for accused 1. The Learned Counsel submitted that the copy of the IA application has not been served. Learned SPB submitted before this court that the copy will be served today before this court for accused number 1. Let the IA 230/24 be listed on 12/12/2024, Your Lordship. Your Lord, and regarding about this order 12/12/24, page 46. It's reflected the Prosecution Counsel's Topeka presence on behalf of the complainant ED. Your Lordship, in the last, since the principal counsel for the complainant is absent, let the IA also taken up tomorrow along with the main complaint case that is on 13/12/2024, Your Lordship. And Your Lordship, in between, the petitioner sought exemption in 2 occasions, and the trial court had allowed for in 2 occasions to be exempted. But as per the section 228 BNSS, exemption is not an absolute. There's no permanent right, and it is a discretion of the court for exemptions of the accused persons. You know. And you know, in executions of 2/531, Your Lordship, Your Lordship may kindly page turn into 29th criminal revision. 29, page 29 criminal revisions. Dated 13/12/2024.
Yes. Now, what do you want to emphasize? What you are emphasizing?
Basically.
Whether the warrant which was issued by the trial court,
Yes,
is it in abeyance or is it in force?
it's in force. That's why I want to explain that it is in force, Your Lordship.
By which order? You just showed me order dated 12.
You know, may kindly page number 52 of criminal revisions. 52. The
Just a minute. 52 is which order?
criminal revision. That is order 22 January 2025. IN number 791, arising out of ML case 1 of 24. Your Lordship. Page 52, Your Lordship.
Yes.
In last paragraph, Your Lordship. It is affected when the notice under FEOA was issued on 24/10/2024. The non-bailable warrant arrest against the accused was kept in abeyance. However, it cannot be said that the non-bailable warrant issued against the accused was not in existence, as no order for cancellation or recalling of the NBW was passed while disposing the IA 531/2024.
Okay, your submission is that as it was not cancelled,
Yes, Your Lordship.
it is yet to be cancelled, only kept in abeyance.
Yes, Your
Therefore,
Lordship.
the requirement of section 2F is complied with.
Yes, Your Lordship.
Okay.
And Your Lordship, with regard to IA follow 21, Your Lordship, in continuation.
Yes. No, we are hearing I4 only. These,
Yes,
now whether there was procedural compliance of the procedural requirement of section 10 of this act of
your regarding the procedure
He-
lectures
he
of
issued
section 10.
10.
Mechanic page, turn the page in 44 criminal revision, Your Lordship. 44 criminal revisions. Regarding about the violation of section 10 of FEA,
What?
page 44 criminal revision.
Yes,
24/10/2024. Your Lordship.
yes.
Zero put up along with the IF 7/91/2024 filed by the complainant ED through the SPB. Good so and so praying for declaration of the accused as fugitive economic offender and confiscations of property thereof under section 10 and 12 of the fugitive economic offense 2028. Your Lordship, the relevant parties. I have perused the application. Accordingly, issue notice to all the respondents, Your Lordship. There is no procedural lapses that the special court does not issue notice to the respondents and applicants or to the respondents. I have perused the application, accordingly issue notice to all the respondents accused as listed in the instance I have, Your Lordship. Fixing 12/12/2024 for replying hearing and hearing on IA issue notice to this application to the accused persons, also through their counsel's appearance in the main complaint case, Your Lordship. There is no procedural lectures that the special courts have violated section 10 of FEA, Your Lordship. Your Lordship, in section 10, economic.
Okay, assuming that this is notice under section 10(1) to the accused. Notice under section 10(2) to the interested persons,
Your Lordship,
whether that has been issued.
applicant to
That-
the accused persons, it has been issued, Your Lordship.
No, the impugned order says that it is waived, it is deferred. In somewhere in the interim, the impugned order, it has been mentioned that because
The matter was fixed on 12/12/2024. However, due to the absence of the principal counsel of the complainant, the matter deferred into 13/12/2024. And Your Lordship, FEO section 10, clause section 10(3) clause A is specifically mentioned that require the individual to appear at a specific place and time not less than 6 weeks from the date of issue of such notice, Your Lordship. Not less than 6 weeks. And from the day of issue of notice, the matter has been supposed to be heard on 12/12/2024. And it counts that on 5th December 2024, it has been only 6 weeks. And this has to be before 6 weeks, Your Lordship. And there is no procedural lapses that the special courts have violated section 10, clause 3 of subclause A, Your Lordship. And clause B stated that the failure to appear on the specific place and time should result in declarations of the individuals as a fugitive economic offender and confiscation of property under this act.
So
And
which-
there are clearly violations of this,
which is
not
the,
by the special court, but by the accused person.
which is the place, when is the date?
Your Lordship, it is there in Dimapur, Your Lordship. The special court
No,
is in
no,
Dimapur.
that order has to reflect that notice should specify the place, date when it should appear, the date when the accused and the date when the individual who is alleged to be a fugitive economic offender and the interested persons are to appear. That date has to be mentioned in the notice. It is only on failure to appear or of their appearance on that date, confiscation of the property may be done. Okay, So your submission is that as by order dated 24/10/2024, the court has complied with the requirement of section 10 of the Act.
Your Lordship.
Okay. Yes.
Your Lordship, may kindly page, on page 29 of criminal revision, Your Lordship. Page 29 of criminal revisions. Order dated 13/12/2024.
Yes.
The relevant questions of origins. Learned counsel so and so presence for accused 1, 2, 3, 4, so and so, and also for exemptions, application for accused 1 and 3. Being IA number so and so, so and so, since with regard to IA, this court has via its order dated 5/9/2024, while disposing the IA 5/31/2024, directed the accused 1 to be present in person. However, IA has failed to accuse 1, Your Lordship, has failed to comply with the direction of this court. Hence, NWB issued against the accused 1, which was kept in abeyance, be executed, Your Lordship. This is clearly mentioned for not complying the court order. He was directed to be present before trial court on the previous occasions. However, on failure to appear before trial court on 13/12/2024, Your Lordship. Hence, the NWB issued against the IA, which was kept in abeyance, be executed, which was reflected in order 22/2025.
Oh,
Your Lordship.
okay.
Which is interconnected with page 52, Your Lordship. The present IA, the present order dated 13/12/2024 is connected with order 22/1/2025, where I have read earlier in page 52 of criminal revision, Your Lordship, which is interconnected. For
Okay.
and Your Lordship, my submissions for the preliminary submissions for this, for staying of this order, Your Lordship. Can turn page number 3 of my affidavit in reply. Page number 3, affidavit in reply, IA 4 of 25, Your Lordship. Affidavit in reply, page number 3. Preliminary submission, Your Lordship.
Yes.
The accused.
You need not to read it. You just tell me the gist of your submissions.
Yes, Your Lordship. The accused persons has satisfied with section 2(1)(f). Your Lordship, may I read out in FEO section 2(1)(5). Fugitive economic offense means any individual against whom a warrant for arrest in relation to a scheduled offense has been issued by any court in India. 1, Your Lordship, has left India so as to avoid criminal prosecution. Number 2, being abroad, refused to return to India to face criminal prosecution. This is a prima facie case that the accused persons have elected to present before the investigation officer, though there are 5 occasions the investigation have issued summons And moreover, even this honorable court have directed the petitioner to cooperate with investigation of investigations officer. WPC 3 of 23. WPC 3 of 23 dated 25th September 2024, Your Worship. This honorable court has directed the petitioner to present before the investigation officer. However, he failed till date.
No, now the question of appearing before the investigating officer is redundant because you have already filed charge sheet
Yes, Your Worship.
without showing him
Till passing of this order, Your Worship. The petitioner
without
does
showing
not
him as an
cooperate with-
absconder.
Yes, Your Worship. And which attract section 2+1 F as well as 2+N, Your Worship. Maybe it's really relevant, Your Worship. Section 2+1 subclause N. Page 2 of FAO in the last year. Page 2. Section 2+1 subclause N, Your Worship. Schedule offense means an offense specific in the schedule if the total value involved in such offense or offense is 100 crore rupees or more, Your Worship, which attract the sections FEO by the alleged person, Your Worship. Your Worship, in page preliminary objection, in page 4, number 6.
Yes.
There are two orders. The original application 8/22 of 2023 dated 11th January 2024 and original complaint 21540, Your Worship. In place of appearance before the adjudicating authority, Your Worship, the petitioners have filed appeals after a delay of 259 days and.
No, but these questions you should have raised before the court in those proceedings.
These are the substantiate where the accused persons.
No, what do you mean by forum hunting?
Your Worship, there's for
Why have you used this word? What do you mean by, in what context you have used this word in your written objection?
Your Worship, there are various companies which was unregistered and used and operate by the petitioners.
No,
There are various-
I just want to understand in what context you have used this word in para 6, that petitioner, whether by filing several cases in several writ petitions and interlocutory applications,
Yes, Lord.
whether it means,
He has shown that there are lots of repetitions filed before this honorable court.
no, whether by filing lots of writ petition in itself would mean forum hunting. Forum hunting means choosing a particular forum. Or what, in what context you have used, I just want to understand.
You know, particularly particular to this particular word. I beg to seek information from the responding
Okay.
Your Worship.
Yes,
Your Worship, the petitioners have filed repetition criminal 3 of 2023, Your Worship, where the request and set aside. However, this honorable court had dismissed and directed the petitioner to cooperate with the investigating agency, Your Worship. And subsequently, criminal 6 of 23, Your Worship. The petitioner also filed to quash the Kohima cybercrime PS 2-3 of 2021 under section 120B 420 IPC read with section 66D IT. However, since the petitioner does not mention in the FIR, this honorable court had dismissed. And Your Lordship, similarly, read petitions criminal 26 of 2024, which is linked with IA
no,
criminal.
what do you want to emphasize by?
All these are dismissed. Yeah, all these cases are dismissed.
Okay.
And then these all are related cases. They are linked cases. Pertaining to this case.
So what is your submission?
Therefore, Your Lordship, the petitioners trying to evade, trying to escape from the allegations offense. However, these honorable courts have